His Excellencies Patrick Chan, Thomas Gao, and Anthony Neo presiding. The President of the Court is His Excellency Patrick Chan. The case before the Special Court for Overland is the prosecutor against Doby. The applicant and the respondent are each allotted 35 minutes to present their pleadings. The audience is reminded to switch off all mobile phones and pagers. No photo taking is permitted inside the court.
Mr. President, Your Excellencies, good afternoon. My name is Celia Torres Villanueva, lead counsel for the prosecution. With me is my junior counsel, Mr. William Varias. We are respectfully entering our appearances before this honorable court on behalf of the prosecution. May it please the court. As the first speaker, I shall require 16 minutes for my presentation. Mr. Varias shall require 15 minutes for his presentation, and we reserve 4 minutes for our rebuttal. Your Excellencies, we are charging Commander Thoby with serious violations of international humanitarian law. We are charging him under 4 indictments. Under the first indictment, we are charging him with direct responsibility for child recruitment on April 5th, 1997 in the village of Ramba, under Article 4, Paragraph C of the statute of this court. Under the second indictment, we are charging Commander Thoby with superior responsibility for the recruitment of child and adult soldiers on April 6, 1997 in Ramba, under Article 4, Paragraph C, and under Article 2, Paragraph C, in relation to Article 5 of the statute of this court. Under the third indictment, we are charging Commander Thoby with superior responsibility for the treatment of children at the RPGC Army Training Camp within the relevant times for the jurisdiction of this court, under Article 2, Paragraphs C and E, and under Article 3, Paragraphs A and E, related to Article 5 of the statute of this court.
We will assume that we have read the papers. You're wasting your own time.
Thank you.
Yes, please.
I shall proceed then. I shall be discussing the first 2 indictments, while my co-counsel, Mr. Varias, shall discuss the third and fourth indictments. For the first 2 indictments, we have 3 submissions. First, we submit that Commander Thoby is directly responsible for the recruitment of child soldiers on April 5th, 1997 in the village of Ramba. Second, we submit that Commander Thoby is also responsible as a superior officer for the recruitment of child soldiers by an RPGC Army recruitment team the next day, also in Ramba. And for our third submission, we are submitting that Commander Thoby should also be held responsible as a superior officer for the recruitment of adult soldiers on April 6, 1997 in the village of Ramba. If Your Excellencies have no preliminary observations at this time, please allow me to proceed with my first submission.
Yes.
Your Excellencies, we submit that Commander Thoby should be held responsible, directly responsible for the recruitment of child soldiers on April 5th, 1997 in the village of Ramba. Child recruitment is a serious violation of international humanitarian law, as expressly provided by the statute of this court. In addition, child recruitment is also a violation of a prohibition found in Additional Protocol 1 under Article 77 and Additional Protocol 2 under Article 4, Paragraph 3C. We'd like to note that Overland is a state party to the Geneva Conventions and its additional protocols. Child recruitment is also prohibited by customary international law. Various conventions and treaties have been signed and ratified by an impressive number of states, signifying the opinio juris and state practice, which are the necessary elements of a customary norm as enunciated by the International Court of Justice in the North Sea cases. We would also like to state that child recruitment is a crime and entails individual criminal responsibility and has been criminalized even prior to 1997 when Thoby committed this crime. Your Excellencies, on April 5th, 1997, Commander Thoby went into the village of Ramba with a few soldiers, and he asked several villagers, including young boys, whether they wanted to join the RPGC Army. To encourage them to join, he emphasized the necessity for winning the war, and he explained the cause for which they were fighting. After his speech, one boy, Apollo, was under 15, and 4 young boys who appeared to be below 15 decided to join. And these are stated very clearly in paragraph 2.2 of the compromise.
But did he know?
Paragraph.
What?
Pardon your Excellency.
What is meant by appear to be?
Yes, yes. The 4 boys appeared to be below 15, but the facts do not show whether they were under 15 or not. However, we submit that this is a relevant fact because the mens rea for the war crime of child recruitment, as described in the Elements of Crimes to the Rome Statute, and as stated by the ICRC commentaries, the mens rea is, which is cited, in which the ICRC...
Sorry for
yes.
interrupting you, but this is not a case of mens rea. This is a pure matter of fact. You have to prove your case beyond reasonable doubt, don't you?
Thank you, Your Excellencies. In fact,
So how do we know that these young boys are under 15?
Yes, Your Excellencies. As to proving that recruitment had occurred beyond reasonable doubt, there's no doubt that Commander Tobey in fact recruited Apollo, who was under 15. So there was in fact already one definite case or count of child recruitment. As with the 4 other young boys, there are 4 also possible children under 15 who may also be recruited. And we are citing the mens rea in that Commander Tobey willfully ignored facts or circumstances which would have placed...
Do we know whether Toby knew about it?
The facts do not show
Now
whether...
this Apollo, a young boy, said he was very interested, very eager to join the army.
Yes, sir.
We do not know from the facts whether he did subsequently join to the knowledge of Toby. Do we?
Yes, Your Excellencies, the paragraph 2.2 of the compromise clearly shows that Apollo admitted that he was under 15 on that date.
With respect, he didn't admit, did he? He said he would turn 15 in a few days. So your whole first indictment really rests on the word of a boy who admired soldiers, their guns and crisp, neat uniforms, who wanted to be part of the army, and who said he was going to be 15 in a few days. You have no more than that.
Yes, Your Excellencies. We submit that the facts as provided in the compromise are sufficient for us to reasonably infer that in fact Apollo was under 15 and that these 4 other boys could possibly be under 15.
Well, should we deal with the fact that the only real fact we have is the word of a boy who says he will be 15 in a few days? Is that sufficient for beyond reasonable doubt?
Unfortunately, Your Excellencies, the best proof would have been birth records, etc. But as Ms. Gracia Michelle and other commentators have stated, during an armed conflict, there are destruction of records and it would be very difficult to ascertain the true age of these child soldiers.
I suppose the strongest point in your favor is that it was an identification check.
Yes.
As opposed, very soon and very easily, the real age of these young boys maybe.
Yes, Your Excellencies.
But having said that, how would Toby know? He was not supposed to be recruiting at that time. And maybe after a long time, he came to know that some of the boys maybe that would be another situation.
Thank you for that.
What we're trying to get out is that at the time of the recruitment, is there any sufficient evidence that he knew?
Your Excellencies, we submit that the fact that they did not have identification cards is a fact that proves that they were under 18. However, as to prove that they were under 15, we submit that that is why we are arguing for the mens rea of the crime. But in fact, Commander Tobey knew that there were facts, and yet he willfully ignored these facts, that Apollo had admitted he was under 15 and that 4 boys appeared to be under 15. He willfully ignored these facts or circumstances which would have placed his conduct within the provisions of the offense, in this case, child recruitment.
The second issue here is really in your particulars of indictment. You haven't quite defined what recruitment means. Recruitment has to follow a certain process. Can you perhaps help us on that?
Yes, thank you, Your Excellencies. Paragraph C of Article 4 of the Statute of this Court describes recruitment as conscripting or enlisting children under the age of 15 or using them to participate actively in hostilities. This provision, in fact, is copied from the Rome Statute elements from the Rome Statute. Therefore, we would like to cite the Rome Statute elements of crimes to look further into the elements of child recruitment as provided in the statute of this court. First, that the perpetrator conscripted or enlisted one or more persons under the age of 15. Second, that the perpetrator knew or had reason to know that these recruits were in fact under 15. Third, that this recruitment occurred, that they were recruited into an armed force or group. And fourth, that this recruitment occurred within the context of an armed conflict. And fifth, that the perpetrator knew that his conduct was within the that he was aware of the existence of the armed conflict. All these, Your Excellencies, are present in this case. Your Excellencies, therefore we submit that when Commander Tobey asked his villagers to join, and these boys decided to join and told Tobey that they decided to join, and then they left the village with the army, recruitment had taken place. Our next submission is that Commander Tobey should also be held responsible for the recruitment of child soldiers on April 6, 1997, the very next day, in the same village. On that date, 5 young boys under the age of 15 were forcibly recruited by the RPGC Army recruitment team and brought to the RPGC training camp near Orverville. We submit that Commander Tobey should be held liable for this act of child recruitment. Commander Tobey is a de jure superior officer of the RPGC Army. His powers and authorities are described in paragraph 2.1 of the compromise. He is a highly influential figure in both political and military matters. He is a senior commander of the Army. And
well, he might be involved in shaping policies, but can we tell whether he was actually involved in recruitment or was in a position to know whether any children have been recruited?
yes,
I mean, you ask Mr. Tone, for example, the chief executive, he probably wouldn't know what's happening in the department.
yes, Your Excellency. Thank you for that question.
So the fact that he was involved in policy making may simply be in his favor.
Thank you for
He
that.
would not be in a position to know the details.
We submit, Your Excellencies, that in Tobey's case, in fact, he did know details because precisely just the day before, he himself had committed the act of child recruitment. In addition, the RPGC has an avowed policy against the recruitment of children, as described in paragraph 1.5 of the compromise. As a policy maker, therefore, he knew or had reason to know that the existence of such policy. And as senior commander, he knew or had reason to know that there was an existing order given to the commander-in-chief to refrain from recruiting children. Therefore, we submit that there can be no reasonable doubt that Commander Tobey had effective control over the RPGC Army, and he knew or had reason to know that child recruitment had in fact taken place on April 6, 1997. In addition, Commander Tobey failed to take reasonable and necessary measures to prevent the perpetration thereof or to punish the perpetrators. Again, knowing that there was a policy, as a senior commander, he failed to implement it. In fact, he set a bad example by recruiting children himself the previous day. As a commander with effective control, he also failed to report any incidents of child recruitment, to investigate, or to punish RPGC personnel. As described in paragraph 1.4 of the compromise, during the decade-long conflict, no RPGC personnel were ever tried or disciplined. Therefore, we hold that Commander Tobey should be held liable for this recruitment. Our third submission is that Commander Tobey should also be charged with superior responsibility for the act of forcible recruitment of adults on April 6, 1997 in Ramba. This forcible recruitment is tantamount to the act of enslavement as a crime against humanity. On that date, an RPGC Army recruitment team entered the village of Ramba and asked the villagers to pay $30 or to join the army. This way, they forcibly recruited 15 villagers who could not pay $30. Your Excellencies, we submit that this act is tantamount to enslavement because there was a restriction or control of the villagers' freedom of choice or movement and their autonomy, which are relevant indicators of the act of enslavement as provided in Prosecutor versus Punaraj by the International Criminal Tribunal for the former Yugoslavia.
Do we know whether this is an isolated event or whether it's systematic?
Your Excellencies, we submit that as a crime against humanity, it is the attack against the civilian population which must be widespread or systematic. And that is clearly shown by paragraph 1.4 of the Complutense, where there are massive and widespread abuses against the civilian population. The act of enslavement itself may be a single isolated act, but within the context of a widespread or systematic attack, it may be a crime against humanity. Since the attack against the civilian population may be comprised of multiple acts, such as murder, rape, extermination, enslavement, and that would comprise the attack against the civilian population separate from the act of enslavement. We submit, therefore, that the act of enslavement in this case was indeed a crime against humanity, being within this context of a widespread or systematic attack against the civilian population. Commander Tobey, being a de jure superior officer with effective control over the RPGC Army, knowing and having reason to know that this act of enslavement had occurred since there was only one training camp in Overland, and this training camp was close to the capital of Orberville, then we submit that I see my time is up, Your Excellencies. May I request for 15 seconds?
Yes.
Thank you. We submit that as knowing or having reason to know, and also failing to prevent the act of enslavement and punishing the perpetrators thereof, then Commander Tobey must be held liable for this act of enslavement as a crime against humanity. I'd like to thank this court for its time and indulgence. May it please support.
Yes, thank you very much.
Mr. President, Your Excellencies, good afternoon. I am William Varias, co-counsel for the prosecution. May it please the court. It is my task to demonstrate before this honorable court that Commander Rupert Tobey must be held liable for crimes against humanity and violations of Common Article 3 and Additional Protocol 2 for the atrocities perpetrated by his subordinates. In support of this contention, I wish to discuss 3 points. First, the RPGC soldiers committed the crimes against humanity of enslavement and imprisonment. Second, these soldiers subjected the children to cruel treatment and outrages upon personal dignity in violation of Common Article 3 and Additional Protocol 2. Finally, Rupert Tobey must be held liable for these crimes under the doctrine of command responsibility. I will also prove before this court that Commander Rupert Tobey must be held liable for intentionally directing attacks against members of the Overland Red Cross Society.
Is there any evidence of intention?
Yes, Your Excellency, the prosecution respectfully submits that indeed the attack committed against the members of the Overland Red Cross Society on February 10, 1998 was intended. Excellencies, the act of pointing the gun in this case by the RPGC soldiers against the ORCS personnel was accompanied by statements to the effect that the ORCS should leave the premises.
What's the meaning of attack?
Excellencies, attack under international humanitarian law means that any unlawful use of force. In this case, Your Excellencies, to enlighten us further as to how the attacking humanitarian personnel is committed, we'd like to refer the attention of this court to the commentaries of the Preparatory Commission to the Elements of Crimes under the Rome Statute. The Preparatory Commission, in that case, in explaining the meaning of attacking humanitarian personnel, unanimously rejected the result requirement. There was no need for harm or violence to be inflicted on the persons of humanitarian workers. It is sufficient that an attack was committed. In this case, Your
This is
Excellency,
an indictment for command responsibility, so these soldiers might have intended the attack, but how could you prove that it is Mr. Tobey who has command responsibility?
yes, Your Excellencies, under Indictment 4, we are charging Rupert Tobey for his individual and command responsibility. For command responsibility, the prosecution submits that Rupert Tobey, a military commander, was duty-bound to ensure that his subordinates comply with their obligations under the laws of armed conflict. In this case, Your Excellencies, it may be asked, what was the specific duty of these soldiers towards these personnel? It is clear, Your Excellencies, that Article 11 of Additional Protocol 2 provides that humanitarian workers shall not be the object of any attack. This prescription is absolute and admits of no exemption. In this case,
If I may just interrupt you for a moment, the facts don't wholly support your allegation, do they? The pointing of the tanks at the Red Cross ambulance took place before the evening news broadcast where Tobey says that the operation is absolutely necessary for the security of the camp. He then says there's no formal prohibition on Red Cross access to the camp, although they're subsequently denied access. Now, firstly, the only act that could be said of violence is pointing the guns, and there is no factual evidence of the involvement of Toby at that point. So it could have been soldiers on a frolic of their own. Secondly, the later denial of access isn't shown to be by any sort of violence. It may have been a soldier with his hand up. And Toby specifically denies any formal prohibition of the Red Cross access to the camp. So factually, are you supportive?
Excellencies, Rupert Thoby was aware of the entire military operation. He in fact inaugurated the temporary hospital in the vicinity. First, Your Excellencies, the RPGC personnel commenced the operation on February 8, 1998, and at the beginning of this operation, the ORCS personnel were already allowed access to the hospital and the camp. In fact, on February 8, 1998, the ORCS personnel were carrying 11 wounded and sick. And it was only on the third day that they denied access to these personnel. Your Excellencies, the fourth indictment is charging Rupert Thoby of attacking these Red Cross personnel for the period covering February 10 to February 21, 1998. And the prosecution respectfully submits that these Red Cross personnel could only be effectively denied access through the actual use of force or the threat of use of force. It must be noted, Your Excellencies, that paragraph 2.7 provides that when ORCS personnel tried to gain access to the camp, they were told that they could not gain access and there was no use of force. But paragraph 2.8 provides a different scenario. When the ambulance tried to gain access to the hospital, RPGC tanks pointed their guns at ORCS personnel. And it could not be denied that they were made the object of the attack because the pointing was accompanied by statements saying they should leave the hospital. And for 10 straight days, Your Excellencies, despite Rupert Thoby's knowledge of the operation, Rupert Thoby did not failed to prevent the further breach of this prescription on attacking humanitarian personnel. As pointed out earlier, Your Excellency, Rupert Thoby inaugurated the hospital and he was aware of this operation because on the third day, he went on radio to broadcast the necessity of this RPGC military operation for the security alone of the RPGC. So that if they wanted to prevent access to suspicious elements like personnel using ambulance units, they could have applied this policy at the beginning of the military operation on February 8. But as the facts show, they only denied access on February 10, 1998. Excellencies, the atrocities committed by RPGC soldiers is tantamount to the crimes against humanity.
Sorry, what atrocities are we talking about in this case?
Excellencies, the third indictment contemplates the acts committed by the soldiers at the RPGC training center. It contemplates...
Yes,
Your Excellency.
But you're not suggesting the 11 dead and 30 wounded. They may have all been soldiers.
Yes, I'm sorry, Your Excellency. I thought I could now go back to my third indictment.
I missed that. Please figure out.
Thank you, Your Excellency. The crimes against humanity of enslavement and imprisonment were committed by RPGC soldiers in the treatment of the children at RPGC's only training center. Excellencies, as pointed out earlier, enslavement under customary law consists of the exercise of any or all of the powers attaching to the right of ownership. The actus reus is the exercise of such powers. The mens rea, the intentional exercise of these powers. The Yugoslavian tribunal, in the case of Prosecutor versus Cunarac, had occasion to state that enslavement is committed when the perpetrator restricts the victim's autonomy, freedom of choice, or freedom of movement. When there is exaction of compulsory labor, and when steps are taken to prevent or deter escape. In this case, Your Excellencies, the facts show that the RPGC soldiers forcibly abducted children and illegally recruited them. Paragraph 1.4 admitted that both sides of the conflict during the decade-long bloody conflict between BUR and overland forces were committing violations of child recruitment. In this case, Your Excellencies, the children were told that they and their families would be killed if they attempted to flee. The soldiers, in order to prevent forcible resistance to illegal recruitment, subjected them to serious physical and mental suffering. In a word, Your Excellencies, the children had to obey all the orders of these soldiers. They had no option whatsoever to flee the premises of the RPGC camp. In addition, Your Excellencies, the unlawful detainment of these young children is tantamount to the crime against humanity of imprisonment. Indeed, Your Excellencies, imprisonment per se under international law is not unlawful. What makes it unlawful is when imprisonment is arbitrary and is committed in violation of fundamental rules under international humanitarian law. Your Excellencies, in this case, under the laws of armed conflict, the protection of children is regarded as an important value, so that aside from the general protection extended to them, the laws of armed conflict, including Additional Protocol 2, extend to them special aid and care, as stipulated under Article 4, Paragraph 3. These children are entitled to privileged protection even if they do take part in hostilities. In this case, Your Excellencies, the children were kept in constant fear. They were repeatedly ill-treated and abused in violation of their human rights, and in order to easily manipulate them to ensure that these children finish their military training. They were told that they and their families would be killed if they attempted to escape. Excellencies,
Could you summarize the evidence which shows that Frobe was aware of all of this?
Yes.
Excellencies, first it must be noted that RPGC maintained only one training center, and this was near the capital of Overland. Second, Commander Rupert Thoby was a former BUR commander before his assumption into the office of a senior military commander. And despite the fact that he occupied such a high position, he continuously involved himself in many RPGC operations, including the trip to the village Barangay and the RPGC operation involving the hospital. Excellencies, moreover, Rupert Thoby had the power to hire and fire subordinates. The international community has prosecuted and convicted the likes of Yamashita, Akayesu, and now Slobodan Milosevic, who, despite of their high position in the military chain of command, were prosecuted because they exercised effective authority. And the prosecution respectfully submits that Rupert Thoby exercised command, that Rupert Thoby exercised authority, and that Rupert Thoby had it within his power to influence the behavior and discipline of these soldiers at the RPGC camp. Rupert Thoby himself was involved in illegally recruiting soldiers, so that the recruitment does not stop there, Your Excellencies. They must be trained for battle, and there was only one training center. Your Excellencies, the abuses committed by Rupert Thoby's subordinates bring us to my next point. Common Article 3 is considered as part of customary law, and cruel treatment and outrages upon personal dignity are two underlying offenses of Common Article 3. Cruel treatment, as decided by the Yugoslavian Tribunal in the case of Milosevic, said that cruel treatment is committed when there is an intentional act or omission which results in serious mental or physical suffering on the part of the victims. On the other hand, outrages upon personal dignity is committed when there is an intentional act or omission which causes serious degradation or an otherwise serious attack on human dignity. Again, paragraph 2.5 show that upon entry to the recruitment camp, the children were separated from their families. They were forced through barbarous initiation. They were repeatedly abused in order to prevent any type of resistance. And finally, they were ordered to kill, maim, and physically injure fellow children who attempted to flee. Clearly, Your Excellencies, ordering young children to kill and maim fellow children is inhuman and must not be tolerated. Rupert Thoby, an influential and respected military figure, must be held liable for these crimes under the doctrine of command responsibility. Again, as we have cited, RPGC maintained only one training center. Rupert Thoby exercised sufficient command or authority and control over the RPGC soldiers in order to initiate a single investigation. But as the facts show, Your Excellencies, Commander Rupert Thoby did not lift a finger to even commence a single prosecution of breaches being committed.
I'm sorry, where's that in the facts?
Excellencies, paragraph 1.6 provides that no personnel from the RPGC or the State of Overland Forces were ever prosecuted.
So your case against him, in respect of these charges, is failure to do something afterwards, rather than planning, organizing, and ordering such atrocity.
Excellencies, a military commander could be held liable under the doctrine of command responsibility upon the showing of three elements. First, the existence of a superior-subordinate relationship. Second, if the military commander knew or had reason to know that crimes were being committed or about to be committed. And finally, that despite such knowledge, he failed to initiate reasonable steps within his material ability to prevent further breaches or punish the guilty perpetrators. The prosecution submits that all these three elements exist in the case. Rupert Thoby had it within his power to influence the behavior of these soldiers. He had the power to hire and fire subordinates. He was actively involved in various RPGC operations.
Your address seems to rely on the fact that he was the only commander. But according to 2.1, he was one of the senior commanders.
Indeed, Your Excellency, Rupert Thoby was one of the senior military commanders. And despite this high position, he continued to involve himself in various RPGC operations, including the trip to the village of Rama.
And we have Article 1 saying the person with the greatest responsibility. How do we know he's the person with the greatest responsibility?
Indeed, Your Excellency, the prosecution, I see that my time is up. May I just another minute to finish my presentation. Excellencies, for the four indictments which we are trying in this case, the prosecution submits that indeed Rupert Thoby bears the greatest responsibility for these events in these indictments. Rupert Thoby had it within his power to influence the behavior of these soldiers at the RPGC Army recruitment camp.
Another senior commander could have equally such impact.
Indeed, Your Excellencies, other military commanders would also be tried for their failure to ensure that their subordinates comply with their obligations under the laws of war. The prosecution right now is charging Commander Rupert Thoby with likewise for failing to abide by his responsibility under the laws of armed conflict. Excellencies, the fundamental objective of the laws of armed conflict is to ensure that the adverse consequences of war are limited or mitigated, especially in the part of protected persons, in this case like children. And in order to implement this fundamental objective, the laws of war have delegated to military commanders the task of ensuring that any breach of the laws of war cease and that penal action is taken. Commander Rupert Thoby horribly failed in this respect. I would like to thank the court for its time. May it please the court.
Thank you very much.
Good afternoon, Mr. President, Your Excellencies. I am Marlon Marquez, lead counsel for the respondent. With me is my co-counsel, Mr. Mark Rabbit. We will be requiring, as for our first submission, 20 minutes, while my co-counsel shall require 30 minutes. We will be reserving 2 minutes for serving up. Thank you very much. May it please the court. Mr. President, Your Excellencies, we submit that Commander Rupert Thoby should be acquitted of the crime charged under Indictment 1 under the principle of nullum crimen sine lege, conscription or enlistment of children under 15 not having been criminalized prior to April 5, 1997. The principle of nullum crimen sine lege, as this court very well knows, postulates that an individual may only be held criminally liable and punished if at the time he commits an act, such act has been rendered as a criminal offense either under a relevant legal order or under specific law. Conscription or enlistment of children under 15 was only first criminalized under the Rome Statute of 1998, which took effect in the year 2004. The acts for which our client, Commander Rupert Thoby, is being charged occurred on April 5, 1997. Given these material dates, Your Excellencies, we submit that Rupert Thoby should be acquitted, as there was no law defining that crime, and hence Rupert Thoby cannot be held liable for such a crime.
That would be a matter of local law. What about the customary international law and the statutes? of this court.
Thank you very much, Your Excellencies. We do acknowledge that there has been multiple prohibitions on the recruitment of children under 15, as can be found under the Geneva Conventions, Additional Protocol 1 and Additional Protocol 2 as cited by the prosecution. And we may add the Conventions on the Rights of the Child and the Optional Protocol on the Rights of the Child, which took effect in the year 2002. However, we maintain that there is a world of a difference between prohibiting conduct and criminalizing conduct. All the treaties and conventions mentioned by the prosecution merely prohibit the recruitment of children under 15 and not criminalize it. On the very contrary, the Geneva Conventions contain specific provisions in Article 49, Article 50, Article 129, and Article 146.
What's the purpose of having such prohibition? What is the purpose of having prohibition?
The purpose of having
Meaning if there is no consequence.
there will be no consequence. This is a matter of normatively defining the normal practices of states without giving penalties or criminalizing such conduct. And in fact, as those provisions state, it is the undertaking of country signatories to determine for themselves and to enact domestic legislation to effectively sanction the violations of provisions of the conventions. More importantly, this undertaking is with specific reference only to grave breaches as defined under the Geneva Conventions. Grave breaches as defined under Article 50, 51, 130, and 147 of all four Geneva Conventions do not in any way include recruitment of children under 15 as a grave breach. Henceforth, we submit that it was never the intention of the Convention to criminalize such a conduct. The prosecution, in its failure to identify a single statute or a treaty or convention specifically criminalizing recruitment of children under 15, touch upon customary international law in order to criminalize such acts. This is reflective of perhaps the principles first enunciated in the Nuremberg trials. If you may recall, those trials held that individuals can be held criminally liable for the new crimes of enslavement, crimes against humanity, and crimes against peace, justifying such decision by saying that certain conduct by their nature or by their nature is criminal.
Wrong, therefore. Are you saying those cases are wrong, wrongly decided?
No, Your Excellencies. However, we submit that this does not apply in this case.
Why?
The Nuremberg trials were correctly decided, but we maintain that, as a matter of fact, this does not apply. The Nuremberg trials, for one, did not include a single prosecution for the recruitment of children under 15. This despite the widely accepted, widely known fact that children were substantially recruited during the wars by the countries participating in that war. This can only mean that the Nuremberg trials did not consider this criminal as to categorize them in the same species as crimes against humanity and crimes against peace, or something so atrocious as not needing legislation to penalize it.
Do you accept, do you, that there was a recruitment of an underage child?
We
You don't seem to address the problem.
we do not accept, well, as a matter of definition, we do not accept that there was a recruitment. And
As a matter of fact, not
as a matter of fact, we would like to define the act of conscription or enlistment of children under 15 as referring to the final stage by which an individual becomes an actual member of the armed forces. The recruitment pertains to that process where of becoming a member of the armed forces. This may start either in posting an ad for the recruitment in the army and entertaining inquiries, soliciting, as in this case, soliciting interest for all those who want to join the army. But this is not But this is not a specific.
Solicitation of interest. They took them away.
Your Excellencies, we would like to submit that there was no taking of children in this case. The facts merely
Are you
show.
suggesting that these children just went away and let's just be hangers-on and watching the show?
Your Excellencies, we do acknowledge and we will refer to the observations by field observers of the ICRC who have raised this as a common phenomenon among war-torn countries, where children who, out of a natural curiosity and admiration for the military, as in fact Apollo admired the crisp uniforms and the guns, is a common occurrence, and that they
You're
raise
suggesting
it.
that they become hangers-on and just show watchers.
Yes, Your Excellencies. We submit that this cannot constitute the requirement for conscripting or enlisting, as this cannot show that they were in fact made part of the RPGC armed forces.
If you were right, would it not say in paragraph 2.2 that in the evening Toby and the RPGC soldiers and militia left the village followed by those who wanted to join, rather than left with those who wanted to join? The word "with" indicates that they were together.
Yes, Your Excellencies.
Not
that-
followers, not camp followers, but actually with them.
Your Excellencies, we submit that as a matter of language, perhaps they may have followed, but we remain in our submission that this does not constitute the being accepted or being part of the armed forces of the
Well,
RPGC.
upon discovering that they were mere followers, as you say, so, I mean, if I'm a commander of the army, I say, what are these followers doing? Shouldn't he be doing something?
We submit, Your Excellencies, that there is no obligation under international law for Commander Rupert Toby to dissuade everyone who would be following or joining the camp. And we further reiterate that Commander Rupert Toby was not recruiting at this moment, and I don't think it came into his mind to personally see to it that that all those who were following or with them were qualified in joining the army. That was not his purpose in entering that village.
So he should have reason to believe that these innocent children may be coming along, and shouldn't he be doing something?
The point is that there could be camp followers or circus, but this is hardly a circus, this is a war.
Again, our submission is that, well, he may be charged under the indictments,
He is
Mr.
not, of
President.
course, charged with disengaging or failing to disengage people. The fact is, if he should have done something to keep these young children away, and he failed to do so, it would be a very strong indication that he was behind all these recruits.
Indeed, Mr. President, we would recognize this as a weakness in our case, and we agree with the observation that this may be an indication, but as I may further discuss, this indication is not enough to sustain the position of the prosecution, if I may.
Yes.
Going back to the principle of nullum crimen, and so as we are not going to be charged with invoking vintage decisions, we maintain that even in the modern tribunals of the ICTY and the ICTR, recruitment of children under 15 has not been mentioned as criminal. The OR's, the optional protocol to the Conventions on the Rights of the Child, signed by 115 countries and ratified by 71 countries, in fact, allow for recruitment of children under 15 under certain conditions. This merely proves that recruitment of children is not criminal per se. Finally, and this is just a month ago, the President of the UN Security Council called on the international community to effect legal measures so as to penalize violators of conscription or enlistment of children. That report contains as an initiatory measure the naming and shaming of countries who violate this particular provision. This can hardly constitute as an opinion among the countries that such act is criminal in nature. Granting arguendo that indeed this has formed part of customary international law, we submit that the prosecution has failed to prove beyond reasonable doubt the act of conscription or enlistment of children under 15. Conscription necessarily refers to some force or compulsion on the part of the recruiter over the individual being recruited. The facts are clear. All those who did not want to join returned safely to their homes. This is highly inconsistent with the idea of conscription. As regards enlistment or enrolling one into the armed forces of the RPGC, there was no showing by the prosecution that children under 15 were selected, brought to camp for training, initiated into secret societies, and enlisted into the RPGC armed forces. There was no instance, there was not a single instance where this may have happened. This therefore is fatal to the position of the prosecution, and we move that there was no conscription or enlistment at this point. Finally, with respect to children under 15 being used to take active part in hostilities, again, there has been no showing or demonstration from the prosecution that children under 15 were used to perform acts of sabotage against the enemy, carry ammunitions or foodstuffs, or transmit orders or information, which all constitute taking active part in hostilities.
And do you mean these children from Ramba in particular, or do you mean generally? Because there is evidence that those who were recruited were used in battlefields.
Thank you for calling my attention to that matter, Your Excellencies. I am referring to the children which Rupert Toby met on April 5, 1997.
So Apollo, effectively, because the rest were only appeared to be.
Yes, Your Excellencies. I would now like to proceed to discuss our submissions with respect to the fourth indictment, intentionally directing attacks against humanitarian personnel and vehicles engaged in humanitarian assistance. For this point, we have three submissions. First, that there was no attack. Second, granting there was an attack, it was not intentionally directed against the ORCS personnel and vehicles. And finally, that Rupert Toby cannot be held personally criminally liable for the alleged attack, for he not having aided, abetted, instigated, planned, or ordered the alleged attack. With respect to the first submission, the single act of the guns, turret guns, pointing to the incoming ambulance can hardly qualify as an attack under international law. An attack being an act of violence directed against an adversary, either in offense or defense. This is because this was not deliberate, as it was, we submit, rather an automatic function of the tank. We refer the court's attention to existing tank technology, in particular, the mechanism called automatic target queuing, which allows the tank's turret guns to point automatically to any moving entity within its vicinity. This technology is widely employed as early as 1990. Consistent with this technology is actually the conduct of the RPGC soldiers who, upon ascertaining
the two... those tanks do have these mechanisms?
Yes, Your Excellency.
And who control these mechanisms?
As to control it, Mr. President, the pointing of the turret guns is automatic. The triggering or firing of that requires human intervention. And I would like to submit that upon ascertaining ascertainment by the RPG soldiers that this indeed was an ORCS ambulance, because we all know that ambulances may be used for perfidy. The ORCS person, the RPGC soldiers merely approached the ORCS personnel and told them to leave, obviously out of security measures, because paragraph 2.9 states that there were sporadic shootings ongoing at the vicinity at that time. Had it been the intention of the soldiers to intentionally direct attacks against the ambulance, they would have readily triggered the tungsten guns and fired, but they did not. Hence, this negates the position of the prosecution that there was intentionally directing of the tungsten guns against the ORCS personnel.
Are we entitled to take evidence from the bar table as to facts such as these when they're not included in the information given to us, the facts which are given to us?
We submit, Your Excellencies, that the rules provide that we can't admit facts if they are logical and reasonable. And we would like to provide the statistics that indeed these tanks, existing as early as 1990, were widely used by the largest manufacturers of tanks, Israel, USA, and Russia, as early as 1990. And we have reason to believe that these were used also in the RPGC. We would like to submit that this can be a reasonable and logical inference from the facts. Mr. President, Your Excellencies, granting that an attack was indeed directed against the ORCS personnel, we submit that this was undertaken as a legitimate military operation under military necessity. We refer your attention to paragraph 2.8 of the compromise, where it is in fact established that terrorists and individuals threatening the RPGC's security were harbored at the camp. This fact placed the nearby hospital at very great risk, and it was for the RPGC's interest to secure, regulate, or seal off that hospital from the general population.
But the Red Cross ambulances are not part of the declaration.
Yes, Mr. President, Your Excellencies.
There were identification symbols, for example, signals, painted all over the place. So
we submit that even if there was a general directive to seal off that hospital because of credible and real threats by terrorists, the ORCS was granted special privileges. In paragraph 2.10, Rupert Tovey, over national radio broadcast, announced that there was no formal prohibition for the ORCS to have access to the camp and to the hospital. He further assured the civilians who would be needing medical treatment, Mr. President, that all those who would be needing medical treatment will be well taken care of. This can only imply of special accommodations and arrangements for the ORCS personnel and vehicles to have access to the camp and to the hospital in order to carry out their functions. I see that my time is up. If I may have 30 seconds to finish my submission. Thank you, Mr. President, Your Excellencies. We submit that the ORCS has never been considered as an adversary by the RPGC, not during the period February 10 to 21, not even the whole period of the decade-long conflict. The RPGC, through our client, Commander Rupert Tovey, has continuously provided the ORCS with all the necessary measures to carry out their functions effectively, including ensuring the safe transport of ICRC reliefs and convoys through various checkpoints in all of Overland. Thank you very much, Your Excellencies.
Thank you very much.
Your Excellencies, Mr. President, good day. I am Mark Pepito Harabatarano, second agent for the defendant, Commander Rupert Thobe. As second agent, it is my task to discuss the indictments to discuss why Commander Rupert Thobe is not criminally responsible for the crimes charged in indictments 2 and 3. To show this, Your Excellencies, I have 3 submissions. My first submission is that Commander Rupert Thobe is not criminally responsible under the doctrine of superior responsibility. My second submission is that there are certain legal elements absent so that there cannot be a finding of enslavement or imprisonment under Article 2 of the statute of this special court. And my final submission is that the child soldiers in the training center do not fall within the purview of Article 3 of the statute of this court. Now, if Your Excellencies do not have any preliminary observations, I shall proceed to my first submission. Thank you, Your Excellencies. We submit that Commander Rupert Thobe is not criminally responsible under the doctrine of superior responsibility. To be held responsible under this doctrine, there are 3 elements. The first element is that there must be a superior-subordinate relationship between the accused and the persons who perpetrated the acts. The second element is the element of knowledge. Under the statute of this special court, this standard of knowledge is that the person know or have reason to know that these acts were taking place. And finally, the third element is the failure to act, which is failure to take reasonable measures to prevent or punish these acts. Under the facts, the first 2 elements are not present. First, there is no superior-subordinate relationship between Thobe and the RPGC recruitment team that entered the village of Rombo on April 6 and the personnel who ran the training center. For there to be a superior-subordinate relationship, jurisprudence sets out certain requirements. In Prosecutor versus Delilich, the court there in paragraph 370 said that there must be command between the person accused and the ones who perpetrated these acts. In paragraph 371 of the same decision, for a civilian to be held responsible under this doctrine, that civilian must exercise power of control similar to that of military commanders. In Prosecutor versus Blaskich, this material ability is the power to prevent or punish these acts. Your Excellencies, under the facts, Commander Rupert Thobe is a senior commander of the RPGC Army. But as early as Prosecutor versus Akayesu, the court already held that mere de jure or formal status is not enough. It cannot be presumed that as senior commander, he had the same powers, functions, and responsibilities as senior commanders everywhere. Now,
here we have a commander who visited the camp, visited the training center, visited the hospital. And so what is he supposed to do, apart from commanding?
yes, Your Excellency, it has to be shown that he had actual power to punish the acts. He had the actual power to command the persons who perpetrated the acts. Now, in indictment 2, the act accused is that the perpetrator is conscripted from the village of Ramba. And in indictment 3, he's being accused of what happened in the training center.
What are the usual powers of a commander?
Your Excellency, under relevant military law, commanders usually have the power to give orders and to be obeyed by their subordinates. But this is not enough once again. We look at the facts. Now, the compromise is completely devoid of any indication of what the duties and responsibilities of Thobe are under relevant military or national law. In the absence of these, we look at the acts he actually did. Now, what did he do? First, he formulated policy. He negotiated the passage of ORCS vehicles. He gave various commands of both civil and political nature. But the question we fail to ask...
Is it more important to know what he did not do?
Yes, Your Excellency, it has to be shown so that he would be responsible for these acts, that he actually exercised power over the people who perpetrated these acts. Now, although the compromise indicates that he had such and such powers, the question to be asked is, did he exercise these powers over the persons who committed these acts? Now, although he had these powers, the compromise is completely silent as to whether he commanded recruitment teams, as to whether he was responsible for the activities in the training center.
But surely a point is reached in the chain of command when you're sufficiently superior that even if it doesn't fall under your specific purview, you are in a position to deal with it. This is a man who negotiated ceasefires.
Yes, indeed, Your Excellency. But in the My Lai cases in 1968, the court there had the opportunity to say that the mere fact that someone is superior does not make him criminally responsible for all the crimes committed by persons lower in rank. In fact, the court there said that this crime must be directly traceable to him, or that this act occurred because of his negligence amounting to criminal negligence. The same thing is in the same mens rea is reiterated in Prosecutor versus Akayasu, and this is serious negligence tantamount to acquiescence or even malicious intent. Now this is not borne out by the facts, Your Excellencies. The second element is also absent, and that is the element of knowledge. Now, I shall proceed on the assumption, Your Excellencies, that he was a superior, but we are not admitting it. So assuming that he was a superior, there is no showing that he had knowledge. The standard of knowledge set out by the statute is that the person know or have reason to know. This standard was reiterated and set out in Prosecutor versus Bagilishema. And this is that the person have an information in his possession which would put him on notice that his subordinates were about to commit such crimes. This is also further set out in Prosecutor versus Delilich. The accused must have specific knowledge within his information which would put him on notice that these acts were about to take place. Now, Your Excellencies, there is nothing in the facts to indicate that Commander Rupert Thobi actually received reports on the activities of recruitment teams. There's nothing in the facts to indicate that he actually knew what was going on in the training center. He was not present at the time the acts took place, neither was it shown that he was in the vicinity at the time these activities were taking place. Neither can constructive knowledge be implied on the part of Commander Rupert Thobi. Constructive knowledge can be had if the acts were so widespread and notorious so as it to be impossible for Commander Rupert Thobi to deny knowledge.
Is it not the case yet?
No, Your Excellencies. Although there were widespread and systematic abuses against the civilian population, this is not the knowledge required under the standard. In Prosecutor versus Bagilishema, in both the trial and appeals chamber, the court there had opportunity to set out what this knowledge is. Now, this case is a case with regard to the atrocities that were taking place in Rwanda at the time. Now, the court there said that knowledge of the prevailing circumstances at the time, and it was indeed well known that there were attacks on the Tutsi population at the time, that is not the knowledge required under this standard. Mere general knowledge of the general circumstances prevailing at the time is not this knowledge, and that is the only knowledge that can be inferred under the facts.
Surely, as a commander, he would see all kinds of people who are conscripted within his army. He would know that his army is suddenly increased in numbers, and he would then have to ask the second in command, where did you get those people? Would he ask those questions?
Your Excellency, he would only ask those questions if indeed he was responsible for these aspects of military operations.
And as Mr. Justice Gold put to you, he's at the top of the power. I mean, he would be the person who would ask these questions, wouldn't he?
Indeed, Your Excellency, he was designated as a senior commander, but this is not enough once again, Your Excellencies. In fact, we look at what acts he actually exercised so that we could tell what his actual duties and responsibilities were. In fact, the facts do not indicate whatsoever that he was in charge of the recruitment teams or that he was in charge of training. Therefore, since the elements of power and knowledge are absent, there is no way that any of the acts in indictments 2 and 3 can be imputed to Commander Rupert Thobi. My second submission, Your Excellency, is that it is doubtful as to whether the crimes of imprisonment and enslavement can be charged under Article 3 of this statute. As early as 1927 in the Slavery Convention and in the Forced Labor Convention of 1930 by the ILO, service related to military activity has been excluded from the concept of forced labor. In fact, it is state practice to conscript. Therefore, the conscription of adults on the day of April 6, 1997 is not enslavement. The same thing can be said of imprisonment, Your Excellencies. Imprisonment has 3 elements as defined in Prosecutor versus Cornelash. First, that the person be deprived of his liberty, And second, there be no legal justification for this deprivation. But the legal justification exists. Again, military conscription is an accepted exception to deprivations of liberty. In fact, it is easily seen by this court that conscription, military service, and training would always entail, to some extent, a deprivation of a person's liberty. And this
Does
is
not conscription be attended by some kind of legislation and legal process?
indeed, Your Excellency, but sometimes it is not. As in this case, when the army is loosely organized and there is no formal structure present, which is why we cannot even tell if Commander Rupert Thobi was in fact responsible for these crimes. My final submission, Your Excellencies, is that Article 3 of the Special Statute of this Court does not apply to the child soldiers in the training center. Article 3 punishes violations of Common Article 3 of the Geneva Conventions and of their additional protocols. Now, Common Article 3 defines what protected persons are, and these are non-combatants or combatants who have ceased to take part in hostilities, or who have ceased to take part because they are wounded or sick. Now, Your Excellencies, the child soldiers in the training center are combatants, and they are not combatants who have ceased to take part in hostilities. Under Additional Protocol 2, even recruits who are under a chain of command and subject to military discipline are combatants. Even in Additional Protocol 2, paragraph 4.3, the statute states that child soldiers who are combatants are still protected, but only when they fall into enemy hands. This is why, as said by the renowned jurist Calchauvin, the protection envisaged by the Geneva Conventions and their additional protocols is not protection against the violence of war itself, but protection against the arbitrary power one party acquires over the person of another. Obviously, the child soldiers in the training center are not in the hands of an adverse party or are not in the hands of an enemy power. Unfortunate as these events may be, they do not strictly fall within the purview of violations of Common Article 3 or their additional protocols. Crimes must be strictly construed and cannot be extended by analogy. Finally, since I still have time, Your Excellencies, I would like to address Indictment 4. Indictment 4 concerns attacks on humanitarian personnel. This is described as other serious violations of international humanitarian law. Now, not just any violation could be considered a crime under this article, it has to be a serious violation. And in Prosecutor versus Tadich, the elements for a serious violation were set out. First, there must be a breach of an international obligation, and second, that breach must involve grave consequences for the victim. That court there made an illustration. If a soldier steals a loaf of bread from the civilian population, he would not be criminally responsible under this article. In fact, although the Geneva Conventions punish stealing from the civilian population and pillaging, this act is not serious enough to fall under to merit the concern of the international community. Your Excellencies, my time is up. May I ask for 30 seconds? The same thing applies here, Your Excellencies. Yes, a gun was pointed at the ambulance, but we look at the circumstances of the case. The camp and the training center were located in the south, where RPGC control is weak, close to the border of a state suspected of giving support to these rebels. Any ambulance that approaches the hospital cannot be simply assumed to be a humanitarian personnel. In fact, in the past, ambulances have been commonly used to deceive the enemy and attack them by surprise. Therefore, when the gun was pointed at the ambulance, it was only reasonable. And in fact, they suffered no grave harm as a result of this. Therefore, Indictment 4 must fail. My time is up, Your Excellencies. You may proceed.
Mr. President, Your Excellencies, once again, good afternoon. In their zeal to acquit their client, the defense has erroneously applied international humanitarian law. First, they are stating that child recruitment has not been criminalized in international humanitarian law. And second, that there was no recruitment that took place on April 5, 1997. Your Excellencies, child recruitment has been criminalized in international humanitarian law even prior to the year of 1996. When the United Nations Security Council adopted through a resolution the Statute of the Special Court for Sierra Leone, they adopted a provision criminalizing or providing for punishment of child recruitment. Through the UN Security Council, the international community has therefore expressed its intention to criminalize child recruitment even prior to 1996. Secondly, we refer to serious violations as described in Prosecutor versus Daggett. We would also like to refer to these serious violations. Serious violations are defined as breaches of important rules or rules protecting important values. Your Excellencies, there are fewer values that would be more important than the protection of our children. And this breach of this important rule results in grave consequences for the victim. An innocent child playing the streets who becomes a child soldier who can be killed or who can kill is a grave consequence for that child. In Prosecutor versus Acquiesce, and many cases of the ICTY and the ICTR, the tribunals have prosecuted serious violations of these rules protecting important values as criminal in nature, in the absence of any statute or treaty expressly providing for their criminality. In addition, there are treaties that enjoin the state parties to criminalize or provide penal sanctions in national law for child recruitment. We would like to mention the ILO Convention for the elimination of the worst forms of child labor, and the optional protocol to the Convention to the Rights of the Child also enjoins strict implementation of the prohibition of child recruitment. And of course, we would like to cite the Rome Statute, which provides child recruitment as a war crime in its provisions. Your Excellencies, we would also like to cite the decision of Prosecutor versus Norman just last year, where they stated that in fact child recruitment is prohibited under customary international law, and that this prohibition does come with individual criminal responsibility when this prohibition is violated. So we are not saying that we do not believe that only grave breaches should be criminalized, but in fact serious violations of Common Article 3, and the fundamental guarantees provided in Article 4, AP2, under which this court shall find child recruitment is in fact prohibited. Your Excellencies, they would also like us to believe that the accompaniment of these child soldiers is not recruitment per se. Your Excellencies, we submit that child recruitment, as defined by the ICRC commentaries, defines that recruitment is any means or fact, formal or de facto, by which a child becomes a member of an armed force or group. To require any formality would be to defeat this prohibition, because during these conflicts, an armed group can easily circumvent this prohibition by simply not enrolling that child in the list, not dressing him up in a military uniform, and not giving him arms. Your Excellencies, we submit that as a general principle of law, these definitions should be broadly or liberally construed so as to afford the broadest possible protection for children, such that they are not allowed to accompany child soldiers as defined in the Cape Town Principles. Child soldiers are all children who accompany armed groups other than purely as family members. Therefore, here there was. Your Excellencies, I see my time is up. May I request for 2 more minutes for my rebuttal? 1 minute.
Yes, please.
Thank you. In addition, therefore, we submit that that active accompaniment is indeed already recruitment and is a violation of international law. We would also like to stress that we are submitting that there is effective control in the case of Commander Thobi, not merely by virtue of his command position. His command position, as stated in Prosecutor versus Alakowski, is merely a significant indicium. It is evidentially relevant, but we have cited many other factors to consider that he has effective control, specifically paragraph 2.1 of the compromise. As to their allegation that there was no attack against humanitarian personnel or installations because of the automatic pointing of the tank, we shall be brief in rebutting this proposition. Your Excellencies, a gun pointed at anyone is an attack. It is an act of violence. And when it is pointed at protected people, including medical personnel, that is an unlawful use of force and is an act of attack. Therefore, Your Excellencies, we respectfully pray that this honorable court adjudge Commander Thobi guilty of all 4 charges. We thank this court for its time and indulgence. The prosecution rests this case. May it please the court.
Your Excellencies, none of the 4 indictments were proven. First, Indictment 1. They cite the Cape Town Principles, but the Cape Town Principles are not law. They are recommendations formulated by NGOs. Second, recruitment was not consummated on April 5. Recruitment is a process, Your Excellencies. What happened to Apollo after he left the village of Ramba? That is a matter of speculation. Apollo, a young, fickle-minded, impressionable boy, followed the soldiers because he admired them. But who knows how long he remained with the soldiers? What if 2 hours after walking around with them, he grew tired and decided to do something else like join the Red Cross? Wouldn't it be ridiculous that we are now convicting Commander Rupert?
Well, he had a few days more to think about it.
Yes, Your Excellency. This is why, since the actual result is unknown, we cannot say that the crime of conscription and enlistment was actually consummated. As to the second and third indictments, they're charging him with superior responsibility. But the only link between Commander Rupert Tobey and the persons who perpetrated these acts is that they belong to the same side. That is all, Your Excellencies. The doctrine of superior responsibility, used as a tool for making sure that those most culpable for certain crimes do not get away with the crimes, is now being abused and used as a dubious substitute for real evidence for linking Commander Rupert Tobey with the ones who committed these acts. Finally, as to Indictment 4, the only participation that can be pointed to with regard to Rupert Tobey of what happened is that he gave in a radio broadcast, he stated that these activities were essential to the security of the RPGC and that he pledged to take care of the civilians. Now, we can interpret this statement in many ways. We can look at it as he was accepting the acts that were taking place and that he was indicating his complicity. Or we can make the inference that he was in fact there to ensure that certain protections afforded civilians under international humanitarian law. Your Excellencies, may I have 30 seconds?
Yes.
Were in fact assured the civilians. We have 2 interpretations, one consistent with guilt and one consistent with innocence. For the former to be adopted, it must be the only reasonable inference. But in fact, it is the latter inference which is more reasonable. Therefore, because of these reasons, Commander Rupert Tobey must be acquitted of all 4 indictments. I have finished my presentation, Your Excellencies. May it please the Court.
What do we do? According to the, do we leave or do you leave?
The session is now adjourned. Will councils and audience please leave the room while their excellencies deliberate? The prize presentation ceremony will commence at 5:30 p.m. at the Hong Kong Red Cross headquarters.